Before I introduce our panelists, I would like to acknowledge with respect the Lekwungen peoples on whose traditional territory I'm joining you from this evening, and whose traditional territory the University of Victoria stands. I would also like to acknowledge with respect the Songhees, Esquimalt, and Wasanic peoples, whose historical relationships with the land continue to this day. And it is my pleasure to introduce our panelists, Chris Siver, and Michelle Embree. Chris is a partner at Mulroney Siver Law and has a UVic and is a UVic Law graduate. He was called to the bar in 2008, and his professional career has been focused on complex litigation, including lawsuits related to wills and estates. Chris is an avid triathlete and coach, and also the president of Run Sport Victoria Society, which is the society that owns and operates the TC 10K. He also shared a PB with me earlier, but I'll maybe leave that for him to share with everybody else. Michelle is a senior total wealth planner with Scotia Wealth Management. She is a UVic Bachelor of Commerce graduate and has been in the financial services industry for 10 years. In her current role, she guides clients through a total wealth planning process that includes reviewing their estate plans and crafting estate tax planning strategies. Michelle lives in Vancouver and enjoys taking full advantage of all BC's outdoor activities, along with her husband and their pup. And finally, I would like to introduce our special guests from Symphony Vineyard, Lamont Brooks and Pat George. This husband and wife team run the winery, and Lamont is a second-generation member of the Brooks family to manage the farm. Both Lamont and Pat have degrees in the earth sciences, with Lamont graduating from UVic in 1982 with a geophysics degree after participating in one of UVic's first co-op programs. So, Lamont and Pat, I'm going to hand it over to you.
Thank you so much, and welcome to Symphony and our family farm. We're going to talk about the vineyard first and then the wine, but we've decided we're going to talk about the wine first. And so that means you can, some of you have already got there, you can open up that bottle of wine, and we're going to chat about those three different wines that you have selected: the Ortega, the Pinot Noir Rosé, and the Pinot Noir. And all our wines here that we make at Symphony are from fruit that we grow here, either on the family farm or locally here on the Saanich Peninsula. So we are 100% Saanich grown, and that's really important to us. And we're going to start with our white, which is the Ortega. May not be familiar for some of you, but it's to me, I really feel it should be a signature wine for Vancouver Island. It's not grown in the Okanagan, so it's something unique to the island. It's great with our island shellfish, Dungeness crabs, spot prawns. So if you have Ortega, please give it a swirl and put your nose in it and see what you get for aromas. Swirl it, have a taste on the palate and see what you're getting. Can you get that melon and white peach? Lovely, lovely aromatic wine, very food friendly and dry. So we also, I think you've chosen tonight the Pinot Noir Rosé and the Pinot Noir. So you can see from the bottles, one is a lovely rosy hue and the other very dark. So these wines are made from the same grape, from the Pinot Noir grape. The rosé comes in at harvest. We press it off right away, treat it more like a white wine, leave it on the skins a little bit to get that lovely color. And if you have that rosé, please go ahead and open it. You should get lovely notes of Rainier cherry and strawberry and hints of violet. Just a really lovely summer sipper on the patio, and a food-friendly wine also. I'd have to say that Pinot Noir is probably one of my favorite wines that we make. It's a different Pinot than you get in the Okanagan or say down in the Willamette down in California. It's a really lovely, delicate, pretty wine. And this is such a versatile wine for food. So sockeye salmon, coho salmon, great with poultry. I love it with duck confit and our sour cherry, rhubarb, toasted black mustard chutney. Just a really fabulous wine. So definitely one of my favorites. So we think the island climate it provides best for crisp aromatic white wines and lighter reds. So that's what we make. And that's what's in your glass tonight. And we hope you enjoy them. You can't make good wine unless you have really good, high quality, disease-free and ripe fruit coming in from the vineyard. And Lamont always scores on that one. So that makes my job easier. And so he's going to talk now about how he does that.
Hi, cheers, everybody.
Cheers.
Welcome. Yeah, Pat's the winemaker and I'm the grower, but we're a pretty small operation at Symphony, so we help each other lots. I am indeed a UVic graduate in physics, actually, not geophysics. There was, I think, one geophysics course in there, but yeah, we were the second co-op stream in physics, so it was a very successful program. I can't speak probably enough about it. Changed the direction of my life completely. And that life started right here on this farm, actually. So yeah, 1957, the year I was born, my grandparents bought this piece of property. When I was a kid in the 1960s, we were growing strawberries and loganberries here, about 30 acres of those. And a lot of the loganberries were for a winery, Growers Winery, which has then got bought and sold many times, is now the big cider company. But Growers Winery was the first commercial winery in British Columbia and was established right here on a peninsula for fruit wines in 1921. And so
Right after Prohibition.
Right after Prohibition, yeah. So the wine they made was called Logana. It was pretty sweet and probably pretty, yeah, I don't know how highly regarded it would be these days, but just to show you what, just in case you're not familiar what loganberries look like, I'm going to put this little picture up there. That's my dad at the far end of the farm, in the middle of the loganberry rows. So
1966.
1966. A little bit akin to grapes, but anyway, yeah. So I grew up here, went to UVic, got the co-op work terms done, and then moved away for 25 years. So I was a geophysicist during that time. Pat was a geologist. That's where and how we met. And then we came back here in 2003. Mom still had 10 acres left of the original 30 and lots of free land down there. So we decided to put in a block of grapes and take it a step at a time. So that's what we did. We planted 6 varietals back then. The Pinot Noir and the Ortega you're tasting, as well as Gewürztraminer and Pinot Gris, Maréchal Foch, and Leon Milot. So the varietals we plant here are very much restricted to some by the climate. So we have a very special coastal climate here. Our climate is dominated by oceanic influences, and that has its advantages and disadvantages. So some of the advantages are we don't get we have moderate temperatures during the winter. Other Canadian wine growing areas have very difficult cold snaps to get through. We don't have those. And we have nice moderate sort of summery weather during our growing season, which it's not enough heat to grow the big reds like Cab Sauv, but there's lots of varietals that work really well here. And some of them work better here than they do in hot climates. And we're also experiencing climate change, of course, as you're probably all aware. And I do a lot of study of that and present to our growers. Things are getting inexorably warmer here. And by my estimates, in 10 or 15 years, we'll have the same amount of accumulated heat during the summer here, which is what dominates ripeness, as Kelowna did, say, around the year 2000. So we're getting warmer. People are going to start, I'm sure, within a few years, start experimenting with different varietals that need more heat. And so, yeah, global warming is nothing to celebrate, obviously, but from the narrow perspective of a winery on Vancouver Island, it's perhaps a good thing. Well, that's all I'm going to say from the grape growing point of view. So I really hope you enjoy the wines. I hope you come out and visit us sometime. We're not far from Butcher's Garden, so it's easy to make a combined trip. And cheers to everybody.
Cheers to everybody. I hope you enjoy the wines in the evening.
Thank you so much to you very both for coming out tonight and for sharing a little bit about the wines and the vineyard with us. And as I said, Greg was the fortunate fellow to go and pick up the wines. So I am very much looking forward to coming out there for a visit and a tasting and to meet you both in person. So thank you very much.
Thank you very much.
Thank you.
And Chris, I'm going to now hand it over to you.
Great. Thank you, Christy. It's a little interesting not being able to see my audience. So I'm just staring off into the black abyss, and hopefully people are listening to this. We'll see. My portion of the evening is not going to be as exciting as wine, but I will start off with the caveat that everything I say is something where there are 50 rabbit holes that we can go down to find something a little bit different. But the gist of what I'm saying is going to be generally true, and then we can have questions about particulars later. So in any event, we start with sort of, in a very lawyerly way, the threshold question: what is an estate? And basically the world is divided into two things: your person and your estate, the legal world, that is. So orders can be made against your person, that's how you get sent to jail. Orders can be made against your estate, that's how you end up having to pay people money. So your estate is things that you have 100% ownership and control of. They are not necessarily things that you have an interest in. So if you're the beneficiary of a trust, or if you have a joint ownership with a child or a spouse, or a sibling, those things are not things that would be in your estate, because they are not things that can be have orders issued against. And then, of course, like I said, there's exceptions and things that we can fight about, but that's the general rule. So because that's the general rule, one of the things that Michelle would be talking to you about is creating an inter vivos trust or a testamentary trust, or having joint ownership. And that's a way of having things not be under the control of the will, because the will, it can only tell the executor to take actions about things that you own 100%. If there's somebody else involved, the executor can't do anything. And of course, as I said, there's exceptions, but very limited. So not everybody needs a will. Most people do. And the main reason that people need a will is because of the result of an intestacy. The rules of an intestacy are that if you have a spouse, that spouse gets everything. If you have a spouse and children, the spouse gets the first 300,000, and then the spouse and children split the rest 50-50. But then you can have two spouses. You can be married and be in a common law relationship because you didn't get a divorce. So there's lots of room for confusion there. There's also, as Greg and Christy are highly interested in, if you want to do charitable giving, that doesn't happen with an intestacy. So, and then of course there's the problem of if there's nobody to give it to, then the government just gets it, and that's the worst of all outcomes. So wills are almost always necessary, assuming that there's a certain amount of money at stake. And I was always taught and tend to believe that you should plan these things as if you're going to win the lottery tomorrow and get hit by a bus the day after. So so generally wills very good. So that brings me to, some of the problems that we end up with wills. And these are the things that keep me busy as a litigator. And that has to do with mainly blended families. That's the thing where there's a most likelihood for trouble to arise. So if you think about a family with 2 kids, the mother dies early, father gets married to stepmom, father dies, the kids say nothing because they're normal people and want to make sure their stepmom is taken care of, and all the money goes to the stepmom, completely thinking that, of course, the stepmom's a normal person, but stepmom isn't, and she gives all the money to other people. So that's a situation that happens a lot, and there are ways to deal with that. They're called mirror wills, and they require a separate written agreement in order to be enforceable. If you just go in and get 2 wills that say the same thing, as soon as one person dies, the other person can change their will. And that's exactly what happened to my clients. The stepmother changed the will 2 seconds later. So with blended families, if you have that agreement, it can work. Always, with all of these things, it's communication. If you are upfront about what your intentions are and the beneficiaries that you perceive are able to have these conversations with you, then it is preferable to have these conversations upfront so that everybody knows what's going on and there's no surprises. It is when there are surprises and expectations are dashed that problems arise. So that brings us to one of the other main areas of friction, and that is when somebody is disinherited, when they expect to be receiving something. In British Columbia, we have the most, depending on your point of view, progressive or regressive widows and orphans law in the British Commonwealth. We have, if you are a spouse or a child who believes they have not been provided for in a manner that meets the moral duty of the testator, they have an absolute right to go to the courts and ask that the will be varied. This is something that doesn't exist outside of British Columbia. Outside of British Columbia, it's you have to show actual hardship before you can go to the courts. In BC, you just have to show that will was not fair. And prima facie fair is an equal division. So there are some rules with that. It has to be spouses and it has to be children. So a spouse is somebody that you are A, married to, or B, in a marriage-like relationship for a minimum of 2 years. And as I said earlier, there can be 2 spouses. So that's a bit of fun. With children, they have to be children. They can't be grandchildren. They can't be stepchildren. If they are adopted, it must be a formal adoption. I mean, there's really no such thing as a common law adoption, but it has to be a formal court-recognized assumption of parental rights, and more importantly, a termination of parental rights on the other side. Because theoretically, if you've common law adopted somebody, they would have a claim against that parent's estate. And that's something that I've had fun. One of my first cases was somebody who abandoned their daughter when that daughter was 3 months old, and because he abandoned her is the only reason he had money when he died. Right, so she was absolutely entitled to that estate. So that was a good fight. So that being said, you can disinherit people if you have what the court has called valid and rational reasons. Now, valid and rational doesn't mean correct. It means that the reasons that you're doing it have to have some underlying truth to it. And the disinheritance is rationally connected to the underlying reasons. So it can be for abandonment, estrangement, physical abuse, or things like that. It can't be because he didn't put mustard on my sandwich on Tuesday. So the other caveat to that is that those valid and rational reasons have to accompany the will. Usually that's done in an outside letter, but it can also be done within the body of the will itself. But it has to be in a place, of course, where it can be found. There's no point writing this letter and hiding it, because if it never pops up, then it can't be used to defend against the claim that will inevitably come. And so the other reason you might disinherit somebody is because they might not be capable of managing a large sum of funds that come to them. You know, the obvious one is somebody who is suffering from a drug addiction. You know, the last thing somebody who is dealing with an opioid problem needs is a couple $100,000. So what can be done are setting up testamentary trusts in which they don't have the right to call on any of the income or capital unless it's been approved by a trustee. And that's something probably maybe Michelle can talk about, or you can talk about to her at another time. And that's also, and then also if they're disabled to the point where they're on persons with disability getting benefits, you don't want to have all of a sudden have them cut off from the other benefits that come with that status, including access to specific medical care. And so we can set up what are called Henson trusts in order to make sure that their needs are met, but their benefits are not taken away. So yeah, so I think that's as far as I'm going to go for tonight. Just sort of close off the idea, though, about taxes. Taxes are a thing that are going to be paid no matter what. Gifts are always tax-free. It's the income from the gifts that end up being taxable, whether it's stocks or interest or it's an ongoing business or something like that. And what you may want to do is control when those taxes are paid, so that has some control over how much. And then, of course, who pays them? Perhaps you want to pay them, perhaps you want your kids to pay them, and that takes a lot of insight and a lot of financial planning, and for that, I'm very happy to throw to Michelle. And so that sort of concludes my portion of the evening. Thanks.
Thank you. Thank you so very much, Chris. I learned some stuff there. I know we have a question at the end. I know we have a question and answer period at the end of this, but I do have a very quick question in regards to disinheriting people. So we have just been informed of a contestant of a will. We are a sole beneficiary of this individual's estate, and this person's spouse is contesting. There was no accompanying letter, but there was, in the will verbiage, it noted that this person's lawyer had informed them of WESA, the Wills Variation Act, and that they purposely did not include their spouse because of personal reasons. Is that valid, or their lawyer likely should have advised them to perhaps outline those personal reasons? But that gets very hard, right? Like when you just said, this is for abandonment, estrangement, or physical abuse. I mean, putting maybe some of your personal reasons, outlining them might be a challenge for people, but I guess if you do them now, then you're not, that's my question.
Well, so I have to caveat this in that I really can't give you specific legal advice, and you'll have to get your own lawyer to do that. But there's a lot of things that are going wrong there. Boy, oh boy.
No, I did not mean to
be
put
on for that.
I didn't mean to put you on the spot. I just thought about, because we have just worked with an individual as well who did provide a letter that accompanies their will.
Yeah.
And it's very clearly outlined. So it's just very.
Well, how do you know what those valid and rational reasons?
Right. So anywho, okay, that's interesting. Anyways, I will not take up any more time. And Michelle, over to you. Thank you, Chris.
Wonderful. All right. Well, thank you. I have a very similar caveat to Chris, where, we definitely could go down a lot of rabbit holes, and I'm sure he would agree wholeheartedly that we could talk on all of these topics for an hour plus individually, so rather than keeping you here for, 5 hours, we're trying to keep it brief. Yeah, really, there's a couple aspects that I'll touch on. One that I'll start with is the tax implications. We get a lot of questions around, well, what do taxes look like when I pass away? How do we avoid them? All of that. And one thing a lot of people don't know is that the CRA could potentially be your largest beneficiary. It's that saying is true. Well, nothing's certain except death and taxes. We can't avoid taxes forever, but there are ways to plan and mitigate what that looks like, and so that can be done through a lot of different ways. That can be done through, utilizing donations. That can be done through life insurance. That can be done through tax planning ahead of time with your company or with your investment advisor to keep different assets either out of your estate, as Chris mentioned, so that we have less taxation, or have it set up so that they're in tax efficient vehicles and they can pass on some of those tax benefits. So that's a large area that really is important to work with a planner, talk to them about, kind of say, okay, what are your goals? And then figure out the best strategy to reduce what those taxes would look like, depending on what way you want to handle that. But another area that a lot of people tend to ask is about what vehicles or options are available when I'm starting or putting together my estate and legacy planning. And there's a lot of different ones. We can look at joint ownership of assets. We can look at trusts. Again, I could probably talk for 3 hours on trusts alone, but different types of trusts, whether those are set up in your lifetime or as part of your estate through your will, those will have different implications for your beneficiaries and tax implications. In Canada, we're very lucky. Also, life insurance is a way a vehicle that we can use for our estate planning. And that can be from an estate growth, so we have as large of an estate as possible. That can also be from a tax planning, as there's tax benefits with life insurance in Canada that a lot of people aren't aware of. Also have, when you were talking about your investments, there's direct beneficiaries that you can name so that those funds can pass on to the beneficiaries and not consider those funds as part of your estate. In BC, we have the unfortunate aspect that we have what's called probate fees. And ours are higher than a lot of other provinces in Canada. So that's another piece that can be planned for and help to either reduce or eliminate what those are through a lot of these structures as well. So it's kind of a two benefits for some of these structures. In terms of who beneficiaries can be, They can really be who you want. They could be a spouse, they could be children, they could be friends, they could be charities. Could be named directly as beneficiaries. And then the tax implications or the probate side is all just going to depend on what that outcome is as to who you want those beneficiaries to be. But charitable donations as a vehicle is also really great from a tax planning perspective, because one aspect that, I'll say it's not specific tax advice, but a general tax rule is that if you have a security, so an investment that has appreciated in value, if you actually donate that security, the CRA will deem that gain to be zero. So rather than paying taxes on how much that security has increased, you actually don't have to pay taxes on that gain if it's securities donated to a charity, and you get the full charitable contribution credit for that market value. And most charities across Canada are all set up to be able to receive securities. So that can be a way to figure out, kind of facilitate the legacy that you're hoping to provide, as well as reduce some of those taxes. Another area that a lot of people have questions about is around timing of gifts. We get a lot of questions that say, well, when can I do it? How much should I do at what time? And working with your financial advisor, a financial planner can be really beneficial, because it's really weighing out a couple of things. You want to make sure that you're not giving funds away too early, where down the road, if we don't know what health care costs are going to look like, or what needs you're going to have, you don't want to run out of money because you've gifted it too soon. But a lot of people, especially now with housing market and how expensive things are, say, I really would like to see my gift being used in my lifetime, rather than waiting 10, 15, 20 years when it might not be as beneficial. Down payment help to kids, seeing a scholarship put in place where you actually get to provide those funds and that scholarship to those recipients during your lifetime compared to when you pass away. Those can bring a lot of joy to people. So, the timing is really dependent on your individual situation. It can definitely be done ahead of time. It doesn't all have to wait to be part of the estate, but it's really taking the time to go through and look at that forward plan and say, okay, do we have enough to make sure that what we're doing isn't going to put us into a hardship later on? And it also provides a lot of peace of mind around that gift as well, whoever the intended beneficiaries will be. An additional thing that a lot of people will think about or talk about when they're looking at the estate planning is not just, the dollar and cents of taxes, but also the idea of what legacy do I want to leave? What do I want to pass on to my successors? And so it's not just in terms of your own life. Sometimes it's what impact do I want future generations to have? What values do I want to pass on to my kids, maybe to my grandkids? Maybe there's values that you received from your parents or grandparents that really carried you through. And really intergenerational legacy planning can be a big piece nowadays, where you may be setting something up in your lifetime so that your kids can start to be part of that and learn some financial literacy, learn what does it look like to choose a charity to donate to? What does it look like to figure out how much you want to donate or be a part of? And the same thing, having that family connection or friend connection, whoever it is, be part of that good that's going to happen long after you pass away, if that's something that you want to put in place. But all of this is really, it's hard to do any of these things in isolation. It's hard to say, okay, I'm going to give a gift here, but I'm not going to think about what that does in the long term. Or, I want to plan for taxes, but I just want to plan for taxes and not take into consideration what legacy you want or what needs you're going to have. So it's really important as you're looking at this to kind of create your team right? Have your legal advisor, have your investment advisor, and include the people that you want as part of that plan. So if you do have a charity that you want to donate to, include someone from that charity. The toughest thing that I'm sure Christy and Greg would agree is when you know or you feel the intent of someone was something, but it might not be worded correctly. A really good example is if someone says, I want to donate to the food bank. Okay, is that the Greater Victoria Food Bank? Is that the Greater Vancouver Food Bank? Is that the food bank in Hamilton, Ontario, because your family was from there? The food bank is very broad and it's hard to know what that intention was. Or if you say, I want to set up a scholarship for the Faculty of Photography. Well, if there's no Faculty of Photography, who is that scholarship supposed to go to, and how do we make sure that that legacy actually goes to who you want and support those people? So definitely working with the team, including those partners, to make sure that you're looking at it from that tax perspective and using the strategies in place that can help reduce taxes, while looking at how to make sure that legacy is going to happen the way you want, and making sure all the wording is correct across multiple documents that might be in place, so that you have that peace of mind to say, this is what is going to happen. I know this is what is going to happen, and I've really taken the time to work through that. And I could go on for a long time, but maybe we'll leave it there in case there's some questions that come up, or if there's something that someone specifically wants us to dive into, we can maybe touch a little bit more on that.
Thank you very much. We do have a couple of questions thus far. The first one, and I'll leave it, and we've got some previously asked questions that we'll ask the both of you. But this one, I wonder, Chris, if this is maybe for you. The question is there a limit on how much I can leave to charity? Could I leave everything to charity, or do I have to leave money to my child?
Well, here's my lawyerly answer. It depends. Theoretically, yes, but likely not. Because there, in British Columbia, a testator has for minor children a legal duty, and for adult children a moral duty to make sure that they are left an appropriate amount in the circumstances. Now, those circumstances can be varied and complex and can include life insurance, payments, can include previous gifts, and help with the down payment on a home, et cetera, but in general, the answer to that would be no, but we could maybe. So there you go.
That's a very lawyerly answer. I'm just wondering, like, it wasn't my question, but to further, like, when you spoke about, disinheriting people, or I guess not including them in their will. So if this was the case that you wanted to leave everything to charity, then you would have, and leave nothing to your child, then you would have to, it sounded to me like from what you said, you would have to have pretty good grounds for not including your child.
Reasons, true things that make sense.
Okay.
And if it's a really big estate, like if you got $10 million and you leave your kids $500,000 each, that's fine. That's okay. But if your estate's $500,000 and you give your kids 20 grand each and give the rest to the SPCA, no, that is not good. So it really depends.
Interesting. Okay. The other question.
Go ahead. I was just going to jump in and add something. I think that's also where talking with your legal advisor, because there's other structures, as Chris mentioned, trusts can be put in place to help, say, okay, this is what I want to happen. How do we maybe move some of those assets outside of the estate box? because trusts are separate legal entities that can't be contested like a will can. With caveats. With
Yeah,
caveats. Is
well,
that better,
yeah.
Chris?
Yeah, because I have 2 lawsuits right now contesting trusts.
Fair,
And
yeah.
so that's all about capacity.
Yeah. So there's definitely, strategies if we say, okay, when you talk with your legal advisor and you talk with your investment advisor and say, okay, this is the situation, can really look at all of those different rabbit holes, as Chris said, to say, okay, what are some strategies to make sure that we're trying to make it the least amount that can be contested as possible, the least chance it's contested, and still provide what you want either to that charity or to the specific beneficiaries.
Okay, thank you both. I'm gonna just ask because I can't see people. If whoever asked that question, if you could just please let Greg know whether or not that answered your question. I'm going to move on to the second one, but if you could let Greg know, then we can circle back if you have additional questions. So the second question is, so if I have beneficiaries listed in my accounts or income tools, can a will override that? Or do they not count if they are not listed in the will? Or what if you list your beneficiaries in your money, but do not have a will? What happens then? So I think the question is like, if somebody so if you don't have a will, but you have like a life insurance policy or registered assets, and you've got people listed on that, and then you do a will, can the will override that?
So, well, maybe
Go ahead.
I'll start and Chris can jump in. If you have a named beneficiary on an investment account or a life insurance policy, those assets typically will not be part of your estate. So even if you don't have a will, those funds will not be part of that kind of legislated breakdown. It will go directly to the beneficiaries. That being said, and Chris can maybe jump in. I would imagine if we have conflicting information where a will says, my RSP should go to my spouse, and then the beneficiary is your RSP should go to your daughter, there may be grounds to say, we want a court to maybe decide what this looks like. But maybe Chris, you can lend your expertise to that.
Yeah, thanks. So if you say 2 different things, one in your beneficiary designation and one in your will doesn't really apply because it's not in your estate. But with a RSP designation or a life insurance designation, it's not going to be as big a deal. But with joint bank accounts, joint investing accounts, and those sorts of assets, equity presumes a bargain and not a gift. So what that means is if you have just put your child's name on the account and you haven't explicitly delivered a letter to that child saying, this is a gift and I intend for you to keep this money and have access to this money and be yours when I die, then the presumption in court is that that child holds that joint tenancy for the benefit of the estate. And then the will does apply. And if there is no will, then the rules of intestacy will apply.
Oh.
And that's a piece of litigation I do fairly commonly as well.
Mm-hmm. And we get that question quite often where people say, well, I don't want to pay probate in BC.
Yeah.
So if I just make my spouse or my child or my grandchild joint on the account, it's not part of the estate. It doesn't form probate, it'll all be fine. But that's not necessarily how it's going to be, as Chris said, if you don't have the right documentation in place for that.
Yeah. And, the gift letter only needs to be a couple lines long. It's not complicated. And so what when there is not a gift letter, it being that's the standard process for qualified, competent solicitors in British Columbia. If they don't do it, my presumption is it was intended to just be a bare trust, and it is for the benefit of the estate, because minimum practice is do a gift letter.
So further to this question, just because again, I'm not entirely 100% sure of the of what the question was, but I'm also wondering if the question related to what if I had, what if I had a $500,000 estate and I had a, $200,000 life insurance policy, and I left the entirety of my estate to a charity, and I left my $200,000 life insurance policy to my child. Could my child then come and say, but so like, I know that a life insurance policy is like outside of probate and stuff,
so
right?
the answer
Like,
to that question is theoretically, yes, the will can be challenged on that basis.
even though they were provided for.
Correct, but the court is entitled to look at the totality of the circumstances.
Okay. Yeah, it's tough reading questions. I wish we could see I wish everybody could ask the questions, right? Because I don't know if I'm getting it right. Okay, I think that answers the question. So, and the questions are coming. So, so further to the life of an estate, trusts will last longer than 3 years. Is the trust still subject to tax in the estate?
Okay, so I guess that one's worded kind of interestingly. So hopefully I will answer it correctly. So if you leave a trust in your estate, so a testamentary trust is set up based on the directions of your will, it does qualify for special tax rules, so a graduated tax rate for the first 3 years, I believe it is. But then after that, the trust will still stay in place. It just becomes now taxed as if it's a regular trust, which is usually at the highest marginal tax rate. It does depend on the type of trust, though. As Chris mentioned, there's, different types of trust, such as a Henson trust, that is a disability trust that has different tax rules. So a trust doesn't automatically end just because the tax treatment will change if a trust was set up as part of your will. But the tax treatment could change depending on how long that trust is in place for. And hopefully that answers that person's question.
Chris, do you want to add anything?
Well,
or?
just the general rule is you have a brief window where the testamentary trust is not taxed at the highest rate, and you need to get all of those assets out of that estate into something else, whether it's another type of trust or distributed to the beneficiaries for 3 years. Otherwise, the trust will start paying income tax at the highest rate. That's all. Maybe that's not a penalty. Maybe there's so much money nobody cares, but most people care.
Mm-hmm. Yeah, and I will say, taxes is a key piece, but we always want to look at tax planning in relation to what is your goal. So some people put trusts in place because, they say, I want these inherited funds and this legacy to be specifically to a bloodline. So they want to make sure that it will always stay with their child and then the grandchildren, and not a spouse that's married in, or not stepchildren that, have come into the picture. And so some people say, I'm okay with the higher taxes because I want this to make sure it stays in this line. So, taxes are a key piece that we try and pay the least amount of is possible. But sometimes the taxes are worth it because that's the structure and the goal of that legacy or funds that you're passing on.
Interesting. That makes good sense. Okay, so another one. So can a power of attorney change or add a beneficiary to a financial product like an RRSP, GIC, etc.?
No.
Okay.
And I will say usually, there's caveats where, the paperwork might change. So for, example, if someone has passed away, and they say, I just want to make sure, it's going to the estate. You can usually say that the estate can be a beneficiary. You cannot change. So, if I'm the power of attorney of my parents, I can't say, I'm going to make the beneficiary me instead of my sister,
Right.
or I'm going to make the beneficiary my child rather than, the SPCA or something like that. The
Okay.
power of attorney doesn't have that ability because they're acting for the benefit and fiduciary duty of the owner. So changing the beneficiary, the government or the courts usually say you're not acting in the best interest by changing the beneficiary to someone different than who the owner originally named.
Gotcha. Hey, well, they're rolling and this is great. Like, it's great to have these questions. Like we said, this is being recorded, so that's great. And then if other people do have, if we run out of time, we were going to give ourselves like a 5-minute break for possibly, a bathroom break or a refill. So we'll just do a couple more questions. We'll take like a quick, 5-minute break and then we'll come back. But let's, so if I have no dependents or spouse and I do not include a sibling in my will, can my sibling contest my will?
No, they don't. They don't have the right.
The answer is no.
No.
Okay. So, okay, next question. So the will states equal
Oh,
distribution.
actually, I'm going to caveat that.
Uh-oh, of course. Okay.
Because if there's an intestacy, then all siblings would share equally. So they might challenge the validity of the will in order to get the will set aside, assuming that if that will is set aside, there's nothing else.
So if there's no will, like if
There's
my
no
brother
will.
did not have a will.
And then he makes one and he cuts you out and just names your sister, you could challenge the validity of the will, assuming that he didn't have capacity. So he wasn't of sound mental awareness. He didn't know what he was doing. He didn't know he was making a gift. He didn't know he was cutting you out.
Okay. Or if I personally chose to leave all my money to a charity and I did not include my brother in my will, could he contest that?
Only if he was able to contest your capacity to make the will.
Gotcha.
Now, you seem pretty upright and with it today.
Yeah.
So
I'm doing good. I've
chances
only
are it
had
would
half a
stand.
glass. So yeah, okay, no, that's great. Next question is, what is the rule against perpetuities? I've asked for clarification, I think, on that one, unless the two of you can clarify.
Gosh, I shouldn't have even said it. I regret it now. It's the bane of all law students. So a trust cannot be set up to last longer than 21 years after the last person to benefit has died.
Okay.
So if you set up a trust to benefit your grandchildren, and you don't know how many grandchildren you're going to have, the last one we'll say is born in 2055, and they live to 2160. At 2181, that trust has to end.
Oh, okay.
So yeah, it's something that rarely comes up, but is an established rule because Ponce English people in medieval times kept their property from the king by setting up these trusts that went on forever.
Oh, how interesting.
Yeah. Most of our wills and estates and property owning rule has to do with landed gentry. So That's where it all comes from.
All right, well, that could be a rabbit hole, right?
No.
But, okay, let's go on. Okay, so will states equal distribution of estate? What are the problems of adult children still in the family home, which is the estate?
Well, it depends do they own it or are they just living there? And if they're living there, shouldn't they be paying rent? So, so no, they're just treated like any other person. They'd probably be pretty upset that they have to leave, but no.
So what if there was 3 siblings, one sibling was still like, and was of a like a legal age, like 18 plus, 3 siblings, one sibling was living there, and everybody got equal of the estate. And then I guess, so I'm wondering if that's the question, like, so then they sold the home and then the one sibling didn't want to sell it.
They give the proceeds to that other person and they go rent somewhere.
Okay.
Sure.
You also, it might be like when someone's dividing an estate, you could say, I want to take my portion and I want to purchase the home from the other 2 siblings, and so you could put in, you could say, because this child is still living at home, I want them to have the first option to purchase the home before you put it on the market. I mean, maybe a little bit in Victoria, but definitely in Vancouver, homes have 12, 15 offers on them. So you could say, what, I want my children to have the first option, either one of them or all of them, to do that first before, it goes on the public market, so that then they could do that, but they'd still have to, figure out how to purchase the share of the other 2 siblings, so that they get their estate portion paid out.
Right, and determine like fair market value of the place. Like you don't get a better deal just unless your siblings agree, I suppose. Like if the house is, if you could put it on the market and get 1.5, but the assessment says 890, like what do you go by? I guess that would have to be determined by the family, right?
Yeah, or you put in, things like, it's going to be determined based on the average of 2 appraisals that are done on the property, or, we're going to take, this is the way we're going to do it, just depending on what that relationship with the siblings are.
Okay. Oh, we've got lots more. Okay, so for the next one, could you talk please a little bit more about trust for disabled legally adopted children and the tax implications? The child will, of course, pay taxes on the income for them.
So to kind of step back, one of the reasons why you would put a trust in place is because a lot of government benefits are income or asset tested. So if you leave a large amount of money directly to that child in their name, then the government may say, well, you have too much direct income, or you have too many assets in your name, and therefore you're no longer going to qualify for the government benefits. So we would use the use of a trust to hold those funds, so it's not in the child's sole name or individual name, and therefore then they would still be able to qualify for those income or asset tested benefits. And then as needed, the trust can pay for things directly. So the trust, can hold real estate for them to live in. The trust could pay rent to, the property manager or whatever is needed. So the tax implications, it's either being paid in the trust or being paid personally. It's not to say, all of a sudden there's going to be no taxes just because you put something into a trust, but it's about structuring it so that we don't lose those other government benefits or tax benefits that come if everything was in a personal name.
Thank you. Next question. If I move outside of BC and I set up my will in my new province or country of residence, do BC rules apply if my children or my family still live in BC?
So BC rules apply to the property or assets located in BC. Okay. The bank account's here, the house is here, whatever it is.
Okay.
But if you move to Alberta and you move your accounts and you don't have any property here, it's Alberta rules.
Okay.
Mm-hmm. The other thing I'll just add, because you mentioned countries, not all countries necessarily recognize Canadian documents. So if you move to another country and you provide a Canadian will, they might say, I don't know, what this is. So for any assets that you have in that other country, you likely want to get legal advice as to what documents you need in that country. And the taxes will kind of depend on any tax treaties and things like that.
Yeah.
Okay.
And Americans have estate taxes,
Mm-hmm.
really big, like 30–40% estate taxes. The flip side for them is they get to write off their mortgage payments.
Mm-hmm.
But
That would be
you
lovely
win
in
some, you lose some,
in
right?
British Columbia.
Yeah.
Okay, is bleeding a RIF or RF to establish a charitable fund, for example, with the Victoria Foundation, I think they meant UVic, a wise move? So is bleeding a RIF to establish a charitable fund a wise move?
So it can be. It depends on the exact situation. In terms of RIFs, when you pass away, whatever the balance is or the value of that account is when you pass away, 100% of that is going to be included as income and therefore taxed. So the idea of bleeding a RIF is usually that we want to take it out over a longer period of time. So we might be taking out a bit more than you need each year, but the idea is hopefully we're taking it out at a lower tax bracket. So we're kind of spreading it out to draw down that balance. So you're not paying all of the taxes as one large lump sum, which might be a higher tax bracket than if you were taking it bits out each year. When you're taking it out and providing funds to a charitable donation, a charitable organization, you are getting the tax credit. You do get a tax credit, and you can account for that tax credit when you pass away as well. So it's not only when you're alive. Any donations that you make as part of your estate will also help reduce your final taxes. So whether it's a good idea or not really depends on your bigger picture, as to how much it's increasing your taxes. Is it pushing you into another tax bracket? How much do you need of those funds for your own lifestyle? If you don't need any of it for your own lifestyle and you want to donate it anyways, it can definitely be a good strategy to draw it out over many years rather than all at once. It really does depend on what your overall income and your tax bracket is and how much we're trying to draw out of that RIF over time.
Thank you. So next question. If a child, an owner of the house, has the right of residence after the other two owners die, how long can that last?
So what I think is being asked here is if there's parents and they've put a child on as joint owner. Well, no, not as joint owner, but given that child in the will what's called a life interest in the house. I'm guessing that's the scenario. So a life interest is a type of trust where they have a right to use and enjoy the property. It could be a home, could be a bank account, but then as soon as they die, that child dies, it goes back into the estate of the other two people, I guess whoever was the last to die between those two people, and then it's dealt with according to that estate. So the answer to that question is as long as that child is alive, I believe. Really, I'd have to see the document that created this situation in order to answer it with any clarity.
Okay, thank you. How much is probate and what assets does it apply to?
So it applies to any assets that are part of the estate. So if you have named beneficiaries on your RSP or your RIF or your TFSA or life insurance policy, as we've said, those are outside of the estate. So it won't qualify, it won't be applicable on that. But any non-registered bank accounts, registered investments that don't have a specific beneficiary, or you've named the estate as the beneficiary, property in your personal name, all of that is all part of your estate. And so probate would be on that. I would have to Google, unless Chris knows off the top of his head. I know it's up to 1.4%, but it is
0.7, I believe, 1.7.
Oh, it went up. Okay, 1.7. Yeah, it's a portion. It's a percentage on up to a certain dollar value, and then after that, it increases as well.
Okay.
Yeah.
I'm encountering a problem where my battery is low on my computer. So I am going to actually need about 3 minutes. In the interest of time, though, Greg, perhaps you could ask the questions, unless, I don't know, I can't see anybody, so I don't know if anybody wants a break, or if we want to just sort of carry on, because there is a lot of questions. Like, we had some as well that came in prior to, so I'm just going to go quickly grab the power cord for my computer, and then, yeah, maybe Greg, you can continue to ask, or to ask the questions that have been posed, and I'll be right back.
Sounds good. The next question
Chris
was.
and I have our bottles, so we're prepared.
Okay, so you're all good. Okay.
There you go. The
Let me
next
tell you
question
another
was, could you please talk about placing assets in trust as opposed to gifting directly to the beneficiary in a will, for example, a house?
Chris, do you want me to take that one, or?
Please, yes.
Okay. So it depends on what your intention is. So if you gift an asset to someone, you no longer have control. So they would then, if you're going to gift it, a child or a grandchild or whoever is going to be on title of, say, a real estate property, they're now the owner, they're now on title. So, you might have tax implications for a change of ownership. But also you no longer have control. So that asset will now be dictated based on what their plans and their estate documents say. If you put it in trust, you can have different stipulations to say, it's going to be held in trust for this person until this amount of time, or when this person passes away, now I want it to go to this next person. So you can dictate that from that perspective.
Yeah, it's a thing called an alter ego trust, and the alter ego trust has the same tax rate as the individual, rather than the highest marginal rate.
Okay. This will be an interesting question, because I think it's very specific to, people moving across provinces. It says, regarding outside of BC accounts, does a Saskatchewan pension plan fall outside of the estate?
All pension plans are outside of the estate because you don't actually own them. You're the beneficiary of it. So it's not captured by the will at all.
Sounds good. The next one, a very straightforward question. It says, a blended family, mother's remarried, new husband adopted one of 3 of the mother's children. Can he exclude the 2 not adopted children?
Oh, what do you think, Greg?
Based on everything that you've said so far, the answer would be no, unless there was a very sound reason why they chose to do so.
Oh, no. Oh,
Okay,
no, of course. No, he can absolutely do it because it's not his children.
Okay.
Should he? It's a whole nother question. But absolutely, he can exclude them.
But even if they're legally adopted, I thought you said they were.
The 2 are not illegally adopted.
Oh, they were not.
One was, the 2 are not.
I should be quiet because I just came back. Okay.
Yeah, only biological children or legally adopted children can contest.
Okay. If a divorce has not been finalized, will the spouse still be able to contest or challenge the will if the relationship has been ended for over 10 years and another common law relationship has been established for over 8 years?
That's why you need a will.
Okay.
because that's a two-spouse situation right there. So actually, this is how I came into Greg's attention. Because as Michelle pointed out earlier, when you are going to be giving to a charity, you need to be precise about what that charity is so that your wishes can be followed. I'm in the middle of a divorce, and my family is small, so I'm just giving to my nephews. My brother died about a decade ago, so that all I've got are my nephews, and so I'm giving to them. But if they die before me, what happens? So I reached out to Greg for the specifics of how to give to UVic, because I specifically give to the law center at UVic, and so if my nephews die and there's any money, the law center gets it.
And we very much say thank you. I've started passing questions both to Christy now, but I'll ask this last one and then I'll pass it back to her. It says, what is the most cost-effective way to establish a legal will? I want to have it legitimate, but I also want to save the cost.
So I'll maybe jump in before Chris does. One thing that was told to me a long time ago, which has always stuck, is that if you think it's expensive to hire a professional, wait until you see the cost of hiring someone inexperienced. So if you don't do it properly and it isn't done correctly, then yes, the cost could actually be more than just spending the money on someone who would do it correctly. I do get a lot of questions of, oh, I liked the lawyer that helped purchase my house for me. I think they can do my will. It's like, if they're not an estate lawyer, they might not put in the correct wording or ask the right questions, things we've been talking about tonight, to make sure that what you're wanting to happen is going to happen, and the chances of it being contested and having problems down the road is minimized. So I think the first key I would say is find someone who does specialize in wills and estates to make sure you're getting the proper advice for your situation. And then I don't know the costs of every lawyer out there, so maybe Chris might have some other guidance on that.
Yeah.
Wait, Chris is offering a discount tonight, I think he said, actually.
Yeah, bring a bottle of wine, will you? I agree with everything that you said, Michelle. I hope we've imparted the idea that there's just enough complexity here that you do need to make sure that people are asking the right questions. My firm, we're a firm of litigators, so we don't really do a lot of will drafting. The will drafting that I do is complex. I do it for complex situations where there's multiple blended families, or there's corporate assets that need to be controlled. Don't really do a lot of simple will drafting, so I'm not sure how much that would cost, but the wills I draft are usually like $1,500, $2,000.
Can I ask your thoughts on, for somebody that has a very simple estate, what are your thoughts on the online will kits? Can I ask you your thoughts? I mean, personally, my first will was done with an online will kit because it was just my husband and I. We had our house, but we didn't have a child. We didn't have a lot of income. And essentially my will said, if I die, I leave everything to my husband. And, my mom can go through my jewelry and my clothes and take what she would like. But that was my first will. And then our second will, we have a child now. So we did go with a lawyer, but I am wondering about, like, for simple estates, if you guys can comment on using the online will options.
Oh boy, I think I'd be committing malpractice if I actually said, like, this could be good, because I really don't know. It depends on your personal situation. What you just described to me there is fine, but also there's actually about 20 questions that I need to ask you to make sure it's actually fine. So
Mhm.
so it really is worth it to spend a few bucks in the first instance to do it properly.
Yeah, and I think as well, what you might think is simple or see as simple, when, as Chris said, when you ask those couple extra questions, it might turn out to be a little bit more complex, so even just in that example, well, what happens when, like you and your husband both pass away? Who's going to be the beneficiary then? And sometimes people don't think about that next step, right? Or they say, oh, well, we'll be each other's executor and handle the will, and then we'll be each other's beneficiaries. Perfect, it's done. But then if you actually both pass away, and you both potentially pass away at the same time, well, now you have no one to be your executor and you have no beneficiaries. So it actually can be more complex than that. And I think, in terms of the cost, I think it would be totally fair to go to a couple, estate lawyers and just say, can you tell me if I have a very simple situation? They might say, well, define simple, but if you say, it's just me and my spouse and we only, own one home and bank accounts, can you give me a rough estimate as to what that would cost, and maybe get a couple quotes from one or two different estate lawyers. I would imagine the simpler it is, it's probably not as expensive compared to when you have a lot of those complexities. But as Chris said, a couple $100 or, even up to $1,000 to make sure that the government at the end of the day, or your sister that you haven't talked to in 20 years doesn't get your money compared to your best friend or a charity, that you would have preferred. So.
Okay, I did make another will. I didn't just use them, but yeah, no, thank you. I do want to go back because I feel like I might not have read this correctly, but with the prior question about the individual, sorry, I'm just trying to go back and find it, who had been estranged, they do have a will. Oh shoot, I'm sorry, I can't find it. They do have a will. I think they had been estranged from they
Oh, right.
right, but so they're saying, but if you do have a will, can the former spouse still contest the will?
Yeah, they are a spouse.
Because they're not legally, so if you're not legally
Yeah.
divorced,
Yeah.
your former spouse can contest the will.
Yeah.
Okay.
Yeah. And then it would be a question of, was there a separation agreement? If there was, what happened at that time?
Okay.
Is it fair?
Okay. So next question, who can be an executor? And I did see, I'm going to just answer this very, very quickly, like from our point of view, because there was a question that said, can UVic act as my executor? And so I'm going to say, no, we can't. We cannot, because that is not in line with our gift acceptance policies. And it's not in line with, ethical considerations. And it's also not in line with capacity, because there's absolutely no way that Greg and I could do all the work that is required of an executor. So that there, I answered one off of our previously submitted questions, which we haven't even got to, but no, UVic can't be, but the two of you could speak, please, to who can be an executor.
Do you want me to take that one, Chris?
Please, yeah, sure.
So most people can be an executor. There's a difference between can you and will they want to be. Most of the time, if you have been an executor once, you do not want to do it ever again, because it can be a lot of work. But you can name a spouse, adult, child, friends, parents. There's professional executors, trust companies, lawyers, their accountants can be named. You really want to look at not necessarily who can be named, but, what type of person would you want? So you want someone that's going to be, available. So usually naming, your grandparent that is 99 is not going to be a good decision. Naming your child that just turned 19 2 months ago, and can barely, handle their own schedule, probably not a good decision. you know, and then in terms of, you know, a sibling or another family member, if they're out of the country, you know, in different province, you know, all of those things can play into it. So a lot of people can be named. It's about who would be the best person in that situation. You know, and it might be as simple as your spouse or your sister or brother. You know, if your child's, you know, in their late 50s and very competent, maybe they want to do it. You know, but there's also those professional executors as well that can step in if you don't feel like you have a personal relationship with someone that would be able to or want to take on the role of being executor.
You do not want it to go to the public guardian, right, and trustee, because that takes a long time to settle the estate.
They're actually pretty good at it.
Oh, okay.
They're a professional trustee. And so if your beneficiaries require some flexibility and original thinking, that can be difficult. So to be avoided, they've got more important stuff to do at the public guardian.
Mm-hmm. Yeah. And there's a lot of creative ways as well. You know, if you name a trust company, you know, you can maybe potentially, depending on the trust company, you know, have an agreement and say, I'd like my kids to be part of or considered in the decisions, you know, but it takes that burden off of the kids from sitting on hold with the CRA or Service Canada to cancel your CPP or OAS, or, you know, filing your tax documents, but they can still be involved in, you know, okay, what price do we finalize on out of 11 offers on, you know, mom and dad's home, or, you know, things like that. They can still kind of be part of it without having to have full responsibility.
Yeah, co-trustees can be a very good idea as well. So one being a child and the other one being a professional, like an accountant or a lawyer or a trust manager.
In the interest of time, I'm just going to point out we've got 5 minutes left, and we have questions that we have not addressed still that were originally submitted. So I'm going to carry on here, and Michelle and Chris, with your permission, if I could send you the any questions that we haven't had time to get to tonight, would it be okay if you answered, and we can send it out with the recording as well as contact information for the both of you?
Sure.
Yeah.
Great. Okay. All right. Well, with 5 minutes left, let's next question. In lieu of formally changing the will, how do we will specific items later on? For example, next year I want the painting to go to child 3. Can we simply create a fluid list that is signed and witnessed and produced at the reading? So in lieu of formally changing the will, how can they, you know?
So I've got two answers. The more formal answer is a codicil. And so that's just an amendment that's done from time to time. It's executed the same way as a will, but it's just appended to the other will. The other thing is just give it to them.
Like give it to them now?
Yeah. Oh yeah. This painting, it's yours.
Okay. And now I'm going back to the original question with the divorce. Okay, if a divorce has not been finalized, will the spouse still be able to contest, challenge the will if the relationship has been ended for over 10 years? Okay, never mind. You did answer that, right? Because it's not been finalized.
Right.
So they could still contest the will. Okay.
Yes, the theory there is perhaps 10 years ago there was a separation agreement and the estate was divided at that time, and so there would be no legal or moral duty remaining to her.
What if the person
would still have the right to challenge the will?
Sure.
You would be forced to go through this terrible process, but in the end, I think the court would say, no, you got everything you were going to get 10 years ago.
Okay. What if they were legally, can your legally divorced spouse contest the will?
No, because you're no longer a spouse.
Okay, great. Okay, so my closing remarks were if there were no other questions. However, you know, we're pushing 3 minutes here. We've got probably 8 questions still that were submitted prior to this evening that we haven't addressed, but I will put those in writing to both of you. But I do just want to extend a thank you to the both of you. This was extremely informative. And I hope everybody who participated also found it extremely informative. And like I say, I was going to say if there's no more questions or are there any more questions, but I'm not going to do that because we've now got 2 minutes left and I just feel like they're rolling in. But this was great. This was really, really great. So thank you. A big, huge thank you to you both. And I hope that you're enjoying the lovely wine from Symphony Vineyards. It truly, I'm enjoying it. It's great. And it's a shame that we couldn't see everybody. But next year we'll do something similar. And if your questions don't end up getting answered tonight or after, with the follow-up, then come back next year. But I am going to leave it on that in the interest of time. And yeah, thank you very much to the both of you.
You're very welcome.
Very welcome.